a lot of the communications, webinars, registration links, materials to help you out throughout this process. So that's a good page to visit and make note of for future references, but we will communicate through the regular channels as well, such as the mailing list and so on. Okay, so today, let me just pause my video so I can make sure we have bandwidth. Agenda for today, I'm going to give you a little bit of background and overview on the development of the program as it emerges, and talk about the scope of this. So which services are applicable, which are not, who needs to abide by the rules that we've established. I'm going to talk about the different certification levels that have been established through the program. A very brief section on the differences between StateRAMP, FedRAMP, and TXRAMP. That's a pretty common question, so I just wanted to call that one out specifically today. Then I'm going to talk briefly about the TXRAMP assessment process, a little bit about the criteria that we are using to evaluate and make a determination on whether or not a cloud service can obtain a certification. And then after certification, the continuous monitoring component. And then I'm going to close out with some additional information regarding some higher level administrative functions and policies around the program. And then luckily, if we have any time left, we can have a session for questions and answers. I'd like to get as many of those answered today as possible. But again, we will review all this information and make sure that questions are being answered. So jumping right into the overview, a little bit of background on how this program has been established over the last several months, beginning kind of in an information gathering stage where we try to identify all the cloud services that are in use by the organization subject to the program requirements, looking at the vendors, other ramps and how those are structured, and then ultimately taking that information and defining our program to meet the needs of Texas and our customer organizations, state agencies, institutions of higher education. With that, we also developed a rule that kind of defines the high-level expectations and responsibilities of the various stakeholder parties involved through these processes, as well as the levels that you will see in just a few minutes here. Communication and outreach right now is really the broadest outreach that we have done thus far. However, I anticipate this being an ongoing thing where we continually develop and improve our ability to communicate the program requirements and make sure that everybody really understands what is needed to maintain compliance with the TXRAMP requirements. And then simultaneously, we've been working on developing and configuring the tool that we're going to use to collect the information, the assessment responses, documentation from cloud service providers so that we can review it and ultimately determine whether or not a certification can be granted. And the go live, as we've envisioned it, we've been charged with standing up this program by December 1st of 2021, and we're on schedule to launch the tool before then. There are a few finalizing steps that we are currently taking in the actual questionnaires that will be launched to the vendors to collect information, as well as the configuration of the different applications that we have acquired for this use within Spectrum. And one other note, we will be hosting a training webinar specifically on the Spectrum piece of this whenever we get that launched into production, which should be in the very near future. And that will go through kind of the nuts and bolts of what you need to do to make sure that your cloud services are in the queue and check up on the queue of assessments and so on and so forth. So that's a lot of more the mechanical side of things. So be on the lookout for that. Again, we'll be posting it on our website and the communication channels, as well as recording the trainings and making guides available as time permits to ensure that you all have the resources needed to successfully navigate the requirements of this program. So first and foremost, what is the Texas Risk and Authorization Management Program, aka TXRAMP? It's essentially a framework for collecting information about the security posture of cloud service providers and the products that they offer, and then determining whether their responses to the questionnaires are in compliance with what we are requiring from the program and reviewing their documentation. So it's a standardized approach or standardized risk assessment involving cloud services. And as Nancy mentioned, this is a charge from Senate Bill 475 of the 87th regular legislative session, and DIR has been charged with standing up this program. And it applies to any contracts that are entered into or renewed on or after January 1st, 2022 for cloud services that store, process, or transmit agency-controlled or agency data. So with that, I'll get to some of the timelines in just a minute, but from a statutory perspective, that is the applicability of the scope. This applies to organizations that are subject to the security requirements of Texas Government Code Chapter 2054. And most broadly speaking, that includes state agencies, public institutions of higher education, and public community or junior colleges. So those organizations are the ones that need to ensure that cloud services have the appropriate certifications before entering into a contract with them after the date stated in bullet number 2 there. So the overall program structure, again, just reiterating, Government Code Section 2054.0593 is what was established through Senate Bill 475, and that's really the broadest level of what this program is supposed to entail. And there it charges DIR with creating a rule around it as well, which we have obtained board approval, and that should be published to the SOS site shortly after it's been approved already. And that really just dictates kind of the higher level requirements. And if you were to get into the nitty gritty of things in the rule, it would be a very difficult and static approach. So within the rule, we also reference program manual and the baselines or the security requirements for each level that then give more detail into the program, such as how to begin this assessment request process, how to determine what level is required for a minimum for a given cloud service, and then the control baselines, as I specified earlier. So as I mentioned earlier as well, we have the TXRAMP webpage at that link right there, and you will find the program manual that was recently approved by our board at that site, as well as the security control baselines. There may be some very minor tweaks to the baselines as I've been going through and crafting the questionnaires. I need to make some clarifications, but largely the controls that are stated there are the criteria that we are looking for in terms of the overall assessment and determination for certification. So I encourage you to go to that site and review the program manual. It will probably explain in more detail than I can do today a lot of the ins and outs of this program, but I will do my best to cover as much as possible and make sure that we're answering our questions. So starting off from a responsibility standpoint, I want to make it clear up front that this is not intended to replace any third-party risk management approaches that agencies are currently doing. It's really there to supplement it. So if you have specific control requirements that aren't defined through this TXRAMP requirements program, such as specific regulatory requirements, in those cases, the agency still has responsibility to ensure that those requirements are being met through your contracting language and so on. It's also agency's responsibility to determine the applicability of a given cloud service as it relates to TXRAMP. So we obviously have some guidelines around what is and is not in scope for this, but the ultimate determination resides within your agencies, your general counsel, executive management. So when you come to DIR and ask, does this require TXRAMP certification? That's really a question that you should be asking your legal counsel and risk management teams to make sure that you're aligned with your overall agency's approach. Now, we do publish and craft the guidelines for determining what is and is not out of scope, but from a legal standpoint, that's a decision that your individual agencies have the ultimate authority to make. So agencies are responsible for identifying, ensuring customer control responsibilities and configurations are satisfied where applicable. So I'll talk about this one a little bit later on, but this is essentially to say, just because DIR has undergone an assessment and granted a certification under this program, there may be additional controls that are the responsibility of the actual end user organization or customer organization to ensure that it's being used right. So that I just wanted to caveat up front and say that every overall implementation can have variability, and that's where you really need to make sure that you're focusing your efforts to ensure that you're using the tool correctly and in a manner that's responsible and in compliance with your security requirements. Agencies are responsible for reviewing security requirements and granting authority to operate. So going back to that last bullet there, the agency ultimately determines whether or not an information system can operate in a production environment with their data. So the authorization piece of this really falls to the agency still. We're just trying to standardize the approach and consolidate and centralize the initial assessment information gathering of this information or the security posture of the cloud service. And then with that, the agencies will then have the ability to add additional requirements, such as the regulatory requirements or whatever organization-specific requirements you have on top of that to make sure that through your contract. And then again, the ultimate responsibility for information security remains with the agency head as per TAC 202. So with that in mind, those are kind of just some caveats I wanted to put up front. This isn't meant to replace your third-party risk management programs or cloud security risk assessments. It's really there to supplement it and give you information in the event that you don't have a mature program surrounding those activities. It will help spread the defense in depth, so to speak, and get better visibility into the security posture than if you were to go it alone. And then DIR responsibilities, of course, we're responsible for maintaining the list of the certified cloud services and providers, making that information available to the organization subject to it. We intend to publish a list of certified cloud services on our public website, and then within the Spectrum portal as well. We will make information available to those users to see the assessment queue, the status of given assessment, to help you plan your procurement activities and make sure that things are flowing without significant disruption to your business processes. We're also responsible for launching the assessments to the vendors, collecting that information, collecting the documentation as part of that, and then reviewing that and making the determination on whether or not a certification can be granted for the given level. We're responsible for providing notifications relating to TXRAMP changes, whether that be from an administrative program standpoint, whether that be from we've granted a certification for this vendor, reminders to vendors to submit their questionnaires, submit their continuous monitoring reports, and so on and so forth. So it's really a coordination role in that regard to make sure that the stakeholder parties are up to date and informed at all times so things don't slip through the cracks. And then DIR is also responsible for determining the TXRAMP administrative actions relating to corrective actions, relating to recertification, grievance processes, appeals, and revocation in potentially some circumstances. So with that, we also have shared responsibilities to really help improve the security posture of the state as a whole. We have to work together, our agencies, DIR, work with the vendors, make sure that we're holding the cloud providers accountable, make sure that we're communicating to our vendors what the requirements are and the processes are. You all have a lot more touch points with certain vendors, and any communication that you can provide is communication that will be well served. While DIR is going to really try to communicate a lot of this as much as possible, whenever you go out to solicit for cloud services or are looking for that and having contact with vendors, making them aware of these requirements is going to help everybody in the long run, because then they will understand what is required of them, what's expected of them, and then we can get on with normal operations once this thing is initially launched. Ensuring accuracy. So I just kind of put this one in here as a blanket statement, but we want to be accurate. We want to be up to date with the information that's being provided. If an agency that has been contracting with a service that has been certified identifies a potential area of non-compliance or something along those lines, you're really on the front lines, and you're the organization that has the visibility to identify and inform DIR if there are potential risks involved with that observation or perceived lack of compliance. with the program. And then DIR can be a enforcement or coordinating role to make sure that that is remediated in a timely fashion to reduce our risk statewide. There could be, probably is, other state agencies or universities that leverage this service. So if DIR can work to expedite and remediate any failings or shortcomings that are identified, that's going to be a win for the state as a whole. Then maintaining compliance. Everybody's got to maintain compliance in this regard. DIR has to maintain compliance with operating the program. Agencies have to maintain compliance by leveraging these certified providers, and so on and so forth. So these are kind of just high level, let's work together and make sure that we're actually achieving something here to reduce risk to the state and improve efficiencies or create efficiencies related to evaluating our cloud service providers. All right, so I'm going to jump into the scope of Texas Risk and Authorization Management Program now. First and foremost, this applies to cloud computing services, and I'm sure most people here are pretty familiar with cloud computing at this time, but we have decided to use the NIST Special Publication 800-145 definition of cloud computing, which is a model for enabling ubiquitous, convenient, on-demand network access to a shared pool of configurable computing resources that can be rapidly provisioned and released with minimal management effort or service provider interaction. So that is the de facto standard that you should first and foremost reference in making determination on whether a given service meets the definition of cloud computing and thus meets the scope for TXRAMP. If it does not meet the definition of cloud computing, then that would be out of scope for undergoing an assessment and obtaining certification. The model has 5 essential characteristics, the 3 service models, SaaS, PaaS, IaaS, and 4 deployment models, public, community, hybrid, private clouds. So I just wanted to put that on there as a reference. That's where it was starting from as a base definition for what cloud computing is. So be sure to keep that on hand when you go through and determine whether or not a given information system or product meets that definition of cloud computing. So with that, out of scope. So within the program manual, we have defined certain characteristics / categories of cloud computing services that would not be subject to the requirements of this program. And those are largely the services that do not process confidential information, or they may be used to create some non-substantive media in some form or fashion. So a bit more concrete here, talking about consumption-focused services. So advisory or research portals where you're obtaining information from another party. It's not state-created data. That has fallen into the out-of-scope category. Graphic design, illustration, media creation, images, sorts of things like that. Again, out of scope. GIS or mapping, email notification distribution systems, social media, survey and scheduling tools, learning management systems or training platforms, then cloud computing services that are required for accreditation or compliance requirements with additional regulations or standards, and then low impact software as a service, which I'll talk about on the next slide as well. But there is a very important caveat to all these categories and characteristics, and that is that provided the cloud computing service does not create, process, or store confidential state-controlled data, except as needed to log in. That would be the only PII, very minimal PII that goes into it. So in this case, if you were mapping or using a GIS service that did contain confidential information, undercover location of all your police officers or something like that, in that case, it would not be out of scope, as it does process confidential information that is requires a level of protection. Same thing goes for a lot of these here. It really depends on how you're using the tool, but if you're collecting health information, PHI, through a survey, then that would fall into scope because that needs to be protected based on these requirements. And then the other caveat to this one as well is if these services connect with systems that process, create, or store confidential data, that could potentially create a security incident that would affect those systems that do store, process, or transmit that confidential data. So looking more towards standalone cloud services rather than those that are fully integrated with something that requires a higher level of protection. And the whole point of this out of scope section is to focus our efforts on the cloud services that possess the most inherent risk and ensure that we are using our resources effectively to manage this risk rather than spending a lot of time reviewing documents and questionnaires, filling out questionnaires for things that really pose a very low risk to the state. So that's why we crafted this out of scope category. And I hope that can let us focus our efforts on what is more important in terms of risk reduction while this program gets implemented. So as I mentioned there, low impact SaaS is also out of scope, again, based on the rationale that I had just explained. And low impact software as a service, our definition is derived from the FedRAMP definition of low impact software as a service. They also noticed that there was undue resources being spent on very low risk items in the overall assessment. So they crafted a streamlined version of an assessment that contained approximately like 35 controls for those to be assessed under. In our case, if it meets the definition of low impact software as a service, we're not requiring a TXRAMP certification. So the first thing it would need to meet is the definition of software as a service, obviously from that special publication I referenced earlier. Does not contain personally identifiable information except as needed to log in. So email, password, whatever it may be. Does not possess, store, transmit confidential information. It is defined as a low impact information resource, which that definition resides in Texas Administrative Code, Chapter 202. I'll touch more on the low impact information resource in a few slides. And then it operates on top of an existing TXRAMP certified infrastructure as a service or platform as a service. So as we go through and certify the various layers of cloud service providers, if there's a low impact SaaS operating on something that's already certified and meets all these criteria, then it would be not subject to having to undergo an assessment and get certified. Now, I do add this here as kind of a disclaimer that agencies really should document the cloud services that have been designated as out of scope, whether that be through low impact SaaS or the categories before, in accordance with your own agency policies. We aren't requiring that you submit that information to us per se, but it is best practice to make sure that you're documenting, keeping an up-to-date inventory of the cloud services that are in use and which ones are subject to TXRAMP and which ones are not. So that's just a best practice, as I mentioned. Okay, certification levels. So within our program, we have established essentially two certification levels. The first one is TXRAMP Level 1. And this is the minimum level required for cloud services that only process, store, or transmit non-confidential data or have been determined to be a low impact information resource. So that or there is important, as in if it is a low impact information resource, but only processes, stores, or transmits confidential information of maybe, I don't know, let's say 5 people. So it does not pose a significant threat to your organization if there were to be a compromise of the confidentiality, integrity, or availability of that system, then at a minimum, TXRAMP Level 1 could be required. Now, if it's confidential or if there's non-confidential data, but it's still determined to be a high impact information resource, then Level 1 is still the minimum requirement. But by all means, I encourage agencies to build in additional requirements from a TXRAMP compliance standpoint. This is the determination for what the minimum level is. So if you want to require additional controls based upon impact of or potential impact rather of the information resource, you're more than welcome to do that. This is just kind of the guiding principles that we set forth to help you determine what the minimum levels for certification are for a given cloud service. And non-confidential data there is a term that we've had to create through the rulemaking process, as we really need to look at this in more of a binary fashion than through the classification of public, sensitive, confidential, regulated. In Texas, it's either confidential or it's public based on the Texas Public Information Act. So with that, there's a lot of gray area around the sensitive piece. So that's why we ended up determining that non-confidential data was a definition that we needed to include through this. Definitions up there. Essentially, it's data that is not protected from public release. And then level 2, that is aligned with the moderate baselines from NIST, and it's for the cloud services that process, store, or transmit confidential information and have been designated as either moderate or high impact information resources, which means those are information resources that either pose a significant or catastrophic risk to your organization if there was a compromise of the CIA attributes. And again, I'll get into a little bit more detail on impact levels in a moment. And then there is a third category that is intended to help us bridge the gap between our timelines with compliance requirements while also leveraging existing risk assessment efforts that have been underway within your organizations and the third parties. The whole approach to this is intended to be a standardized approach to conducting risk assessments on these cloud services. And there's a variety of different frameworks and criteria that are out there that folks use to gauge and make a determination on whether or not a cloud service has an acceptable level of risk associated with it. So we wanted to be able to leverage that, and it gives us a certain amount of assurance that there has been due diligence performed in the review of this cloud service, enough so that we could grant a provisional status certification while we then direct that service to undergo the standardized approach that ultimately ends up with either a level 1 or level 2 certification. So the provisional status certification is level agnostic. So we are not going to have dual routes for the provisional status certification. That is going to be a blanket, but while the service undergoes the direct assessment, I guess you could call it, that is where the service will make a determination on which level it ultimately seeks a certification for. And there's 2 ways to achieve the provisional certification, and that's either through an agency sponsorship. And I'm using the term agency as a blanket here. Agency refers to the organizations that are subject to the TXRAMP requirements, or through an independent third-party assessment audit review. And I'll illustrate those in just a moment. And another thing to note, for the provisional status, that is valid for 18 months from the date it is granted. So that is intended to give sufficient time to the cloud service provider to undergo the assessment where they provide their control implementation details and documentation, and DIR can review that and grant a certification if it is warranted. So, impact determination. This is just carrying on from the certification levels here. I wanted to expand it a bit more detail on what the low, moderate, and high impact information resources are. And these are all defined in Texas Administrative Code, Chapter 202. And as you can see here, low impact has a limited adverse effect on operations, organizational assets, or individuals. And it's a bit vague. There's not numbers assigned to it because each organization may have different risk appetite and have a different definition of what significant and minor are in these cases. But I wanted to include it here for reference so that you have something to work with when it comes time to determining whether or not a cloud service falls to a level 1 or a level 2. So with that, we will provide these slides as reference as well, but these definitions are established in TAC 202. Okay. So who actually determines the certification level? This one is a bit of a complex question, and it kind of, the answer is kind of, it depends. So the contracting agency should ultimately select the appropriate TXRAMP level based on the confidentiality requirements. So the contracting agency will know what data, the sensitivity of data that are to be included in the cloud service. And they will also know what level on that impact scale that the information system or cloud service falls into. So with that, the contracting agency should work with the vendors to determine that they need a level 2 certification if they've got PHI and it's a significant could potentially disrupt a lot of the primary functions of the organization. In those cases, it's really the agency that should determine what the minimum level is based upon those criteria that we specified a bit earlier. And then if a provider is seeking certification without a contracting agency involvement, so if it's just a vendor that's probably or potentially not doing business with any state entity currently, they can still request a certification be performed. We will prioritize the assessment requests that have been sponsored or initiated by an organization subject to the program requirements prior to focusing on those that are vendor initiated without any contracting activities in place, but we're not closing it down just to those agencies to make those requests. And I'll get into all that in just a bit. And then on that note as well, if there is a level selection conflict that exists across multiple contracting agencies, say agency A is leveraging the service and deems it's a moderate impact system and has confidential information, agency B says, no, it's a low impact information system for us, then in those cases, it's really the provider that should make the appropriate selection. Obviously, the agencies can have input and convince or communicate to the provider that we require this as our level. So then we can tailor and modify the target assessment level to make sure that the coverage exists and that your agencies are staying in compliance. And then on that note as well, if a service provider or cloud service has obtained a TXRAMP level 1 certification, then they may request that a TXRAMP level 2 certification or assessment rather be performed as circumstances necessitate. For instance, if they are looking to contract with another agency and that agency is requiring level 2, then in those cases, we can build off of the level 1 certification and help that vendor go through the assessment process to ultimately get certified at a level 2 as needed. All right, I'm going to talk about the timeline requirements now. So staying in line with the statutory language there, we decided to prioritize, again, the cloud services that possess the most inherent risk based on the impact and confidentiality requirements associated with it. So if a cloud service requires a minimum of the level 2 certification, it is required that that cloud service be certified under TXRAMP by January 1st of 2022 for the agencies subject to this program to enter or renew contracts. And then for cloud services that require level 1 certification, they need to be certified under level 1 by January 1, 2023 for agencies to enter or renew contracts. So it really depends on that level determination as to when these certifications need to be in place, otherwise be in violation of statutory language. And then cloud services granted TXRAMP provisional certification will need to obtain either the TXRAMP level 1 certification, TXRAMP level 2, or an equivalent, which I'll get to in a moment, within 18 months from the date the provisional certification is granted. So it's a good practice to make sure that that is initiated early so that there is plenty of time for that cloud service provider to complete the assessment and upload documentation so that they can achieve the full level 1 or level 2 certification going forward. And then one other note on here as well, existing contracts for cloud services do not need to have that cloud service certified until it is either renewed or a new contract for that service is executed. So if it's essentially grandfathered in until the end of the contract period. So keep that in mind as well. That date for January 1, 2022 would be for only the new or renewed contracts for cloud services that meet level 2 definition. So with this, our whole intention is to ensure that we have adequate time to fully dedicate our resources and accurately and thoroughly vet these cloud service providers to be able to grant that eligibility for certification. Okay, accepted documentation / evidence for provisional status. So DIR will accept a third-party security assessment or audit report, essentially artifacts and documentation relating to that third-party assessment or independent audit to take into consideration in determining whether or not provisional status may be granted. And there's two paths to achieving the provisional status, as I mentioned before. The first one is the agency-sponsored request. And in this event, an agency will notify DIR through the Spectrum portal that you want to sponsor this cloud service for provisional status, and then tell us what criteria was used, what risk assessment, what questionnaire you evaluated on, when it was performed, what level of authorization for impact, low, moderate, or high you've authorized this service for, as well as kind of a generic, is there anything else we should know about question where you can provide additional details if applicable. The agency does not need to provide raw results of the risk assessment that they conducted, but we are asking for what the underlying criteria were that were used to evaluate and ultimately approve that cloud service for your organization. So common assessments in this regard would be HECVAT, higher education, CAIQ, which is a questionnaire from CSA STAR, Center for Internet Security, Critical Security Controls 18, TAC 202, SOC 2, the list goes on and on. Those are just some of the more common ones. So if you have conducted assessments on cloud services in the past using these, and it's a fairly recent assessment, then there's a high likelihood that that would be given the provisional status based upon your approval of that product. And then the other side of this is through a third party attestation, audit, essentially anything that is viewing the security posture of that cloud service from an independent or objective lens. This is probably going to be the path that a lot of vendors that may not currently be doing business with agencies go through, but still want to obtain that provisional certification in case they want to do business in the meantime while they undergo a level 1 or level 2 assessment. So in this case, the provider can complete the assessment request form, which I talk about in a bit. We will launch a questionnaire to that vendor where they can then provide the evidence and documentation relating to that third-party audit or assessment. Common artifacts in this regard would be SOC 2s, your ISO 27000 certifications, a CSA STAR certification, regulatory audits, and so on and so forth. So essentially, if it's an independent audit that looks at the security posture of the cloud service and cloud service provider, that could be submitted for DIR's review to determine if we can grant that provisional status certification. This just illustrates kind of those two paths to the same end result. One would be through the agency approval and the other would be through a third-party attestation. Either way, we are looking at a third-party review of the security posture and then ultimately deciding whether or not a provisional status can be provided. Okay, now I'm going to jump into StateRAMP, FedRAMP, TXRAMP. What are the differences? What are the similarities? There's quite a few going on here, so I felt necessary to call it out. So if something is StateRAMP or FedRAMP authorized, or there's certain statuses within here which we accept, and essentially those are the verified offerings, then we will automatically certify it under TXRAMP. We've based all this on the same criteria and based a lot of the ins and outs on these programs as well. So we have decided to accept that in lieu of undergoing a TXRAMP assessment on that product. And we will be doing so through the FedRAMP marketplace and the StateRAMP authorized vendor list, and updating that at a regular frequency. So if you're unfamiliar with these, I encourage you to take a look. FedRAMP is, well, I'll get into that in a second, but this is where they post the cloud services that have been authorized or are in process of obtaining a appropriate status or authorization under these programs. And now I can get into some more of the differences here. So TXRAMP, StateRAMP, and FedRAMP. First of all, we're all based on NIST Special Publication 853, Revision 4 controls. Both StateRAMP and FedRAMP are in the process of migrating and aligning to Revision 5, which I anticipate we will do as well. But given that we have not adopted the Rev 5 language or controls for the state controls catalog, that it made more sense to base it off Rev 4 initially. And then as Rev 5 implementation requirements start to come in the future, we anticipate updating that and aligning to the newest revision as well. So for now, we're all aligned on the same criteria and largely interchangeable in terms of what the control requirements are. StateRAMP and FedRAMP utilize a third-party assessment organization to review the security posture, assessment, and documentation of the cloud providers that are seeking a authorization under their programs. DIR is going to perform the assessment in-house, so we're kind of acting as the PMO/3PAO at the same time in this regard as we've been charged. There is a cost associated with StateRAMP and FedRAMP. I'm not sure of what the actual amounts are, but there's no cost to undergo an assessment through TXRAMP. The impact levels are also a distinction here. Impact level in our case is determined by the TAC 202 definitions of the low, moderate, and high impact information resources. In StateRAMP, they've developed a classification tool, data classification tool that helps determine which level is appropriate for a given service provider. And then FedRAMP obviously is leveraging federal standards through FIPS 199 information types and the low, moderate, and high requirements for confidentiality, integrity, and availability to make those determinations. Continuous monitoring, aka CONMON. FedRAMP only provides continuous monitoring information to federal agencies that are involved with that FedRAMP program. So StateRAMP was actually established as kind of a response to that, that is intended to bring together state and local governments and provide that information in a single pane of glass, similar to how FedRAMP does it for federal agencies, but that information is restricted just to federal agencies. So StateRAMP has served that same kind of capacity in the public sector across different states and local municipalities. Our CONMON, our continuous monitoring reporting, will be available to the agencies that are contracting for the cloud services through the Spectrum portal. And there is a process that will be established in how to associate your organization with the given cloud service so that you have access to the continuous monitoring reports that will be provided by the service provider on a regular basis. And that way you or DIR can serve as that single central repository and hub, and we don't have to have the vendors reporting 50 different times and 50 different formats. Although, again, agencies can add their additional requirements if there was, a requirement for more frequent continuous monitoring or anything specific to your organization. TXRAMP is mandatory for state agencies. Again, those entities I mentioned earlier. StateRAMP is not mandatory at all. It's a 501c3 organization. It's a non-governmental organization. And then FedRAMP is mandatory for federal executive agencies, and they must do business with federal government. So TXRAMP, again, does not require having a current contract with a state entity. If there's a vendor that's seeking the certification without a current contract, then they may submit an assessment request. Again, however, that it would be prioritized lower than those that have active contracts or are seeking contracts directly. So those are kind of the differences at a high level from our perspective as at TXRAMP here. And then the levels as well. So as I mentioned earlier, we will automatically certify a cloud service if it has a respective approved status under StateRAMP or FedRAMP, and this is how our levels map to their levels. So our level 1 aligns with the FedRAMP low, that's the NIST low baseline, essentially, with some additional parameters, and StateRAMP category 1, and they have a subcategory called either 2 or 1+, which has some additional controls, but largely that maps to our level 1. And then for our level 2, that maps to the moderate baseline for FedRAMP and StateRAMP's category 3. We do not have an additional high certification level in this case. Level 2 is the minimum for us, but if you require a high certification or authorization for a given system, typically that would be routed through FedRAMP as well. But then again, you can also build on your own organizationally specific requirements on top of that level 2. So again, we're talking, these are the minimum requirements to be certified through TXRAMP. And then below here, there are various statuses associated with these categories. So the verified offerings are those that have been reviewed by the third-party assessment organization and deemed appropriate for use. So within our program, we really only have either certified or not certified. So it could either be provisional or the level 1 or 2. StateRAMP has ready, authorized, and provisional. And then FedRAMP has ready, provisional authority to operate, which is granted by a joint advisory board, a JAB, I'm not sure what the actual acronym is, or an authority to operate, which is authorized by one of those federal executive agencies. So those are the offerings that will accept and automatically certify under those programs. And then you can see below that, there's the progressing offerings, which means that they are pretty much in the process or have signed up to get certified or authorized, depending on terminology, through one of these programs. So with that, we will have more information that kind of helps you identify what it is, but we will be populating in Spectrum the inventory of certified programs based upon the statuses of both the marketplace with FedRAMP and the authorized vendors list with StateRAMP going forward. Okay, going to talk about the assessment. I think we've got about 40 minutes left, so doing all right on time. Assessment initiation. There are a few ways to initiate an assessment here. A state agency may submit a request for assessment of a cloud service directly through Spectrum. And again, there's going to be documentation and training on the Spectrum piece of this, provided that the state agency has the appropriate information to submit that request. So we're going to need things like the contact information of that cloud provider so that we can correspond with them and make sure that the target assessment level is appropriate, and so on and so forth. A vendor may also initiate a request without an agency sponsorship through this external web form, a TXRAMP assessment request form that's already available out there. A state agency may, this is really just a suggestion or a consideration for agencies, but if you're soliciting a procurement for cloud services, you may write into your contract language that anybody that's bidding on that fulfill or complete the TXRAMP assessment request form. And then if you down select, then you can go in and sponsor that one for an actual assessment to expedite the review of the assessment results and obtain a ruling on whether or not it's certified. So that's just a suggestion. One of our agencies had built that into one of their processes. I thought it was a good idea. It's not a requirement of the program, but that is something to keep in mind. And then once a vendor or agency has completed that assessment request form, DIR will import that information on a regular basis into Spectrum. And then from in there, agencies can view the list of those that have been populated and determine whether or not they want to sponsor it for a request for assessment, which would assist in our prioritization of reviewing and conducting the assessment review. So that's not the same as the sponsorship for provisional status. This is essentially saying you're upvoting it to say, we would like this assessed because we do business with them, or we have a potential procurement upcoming and they are on the list of entities that we're highly considering. So the more agencies that would sponsor an assessment request would increase the prioritization level, but there are other factors that we take into consideration because we want to ensure that there's minimal disruption to business through these processes. Here's some of the information that is required to complete that assessment request form. So we're going to need, obviously the cloud service provider contact information, name, if there's a DIR contract currently, that's if applicable, from the vendor side, information about the cloud service itself, procurement information, is this a current contract, is it up for renewal, et cetera. All this kind of information helps us prioritize and make sure that we're focusing on the things that need to be focused on first and foremost. And here's the direct link. Again, these will be sent out, and the form is in the program manual, and I believe it's on the website as well. Either way, it's pretty readily available. Prioritization, as I mentioned, we will process them in order that they come in, but we have factors that we're taking into consideration when it comes time to actually reviewing the assessments. We will launch the assessments, obviously, as expeditiously as we can. It's more of a matter of when we get the assessment results back, how do we prioritize our workload to make sure that those that need to be addressed the fastest are being addressed the fastest. So we're going to look at things like existing authorization certifications, this agency described priority from low to critical. We want to make sure that there's some input from the agencies themselves, as well as the schedule of procurement activities and the certification requirements based on the level. So there's a lot that goes into this, but again, these are just to let you know, we are focusing and looking at this kind of a holistic approach to make sure we're minimizing any disruptions to your procurement and business processes. So the control assessments itself, these are the controls or counts of controls by family for the various levels. Level 1, approximately 124, level 2, 325. Again, these may be slightly tweaked based on clarification that after building out the tool and looking into great detail, some may not apply, or the parameters may need to be slightly updated based upon the program manual requirements. But the controls that are listed within the baseline control document on the website are the controls that we are basing our assessment off of. So yeah, it's quite a bit. Obviously, we're focusing on the areas that are of significant importance to cloud security, access control, auditing, really some of the visibility controls, which is one of the major issues with cloud security is not knowing what you don't know. So access control and auditing and so on and so forth are important in these regards. That's not to say that the other ones aren't important, but you can see how those have been kind of highlighted. Identification, authentication as well. So the controls assessment will ask the organizations, the vendors, to answer these questionnaires, to upload their documentation, and to provide justification or evidence in some respects if there's a control that requires that, as well as some of the inheritance functionality within these controls. This is just a screenshot of what the vendor portal looks like. We will launch this questionnaire to a targeted vendor contact. They can then assign other individuals to certain sections or questions and track the progress throughout the assessment. As you can see here, this one's pretty straightforward. As long as the vendor has the same email domain, they'll be able to add as many folks as they want. If they have a separate email domain than what was targeted for the assessment launch, then they'll either need to coordinate that information or we'll need to relaunch it with the appropriate email domain and contact so that they can distribute this and we can automate the information collection as much as possible. Required documentation, this is listed in the program manual. We are not prescribing a specific template for these documents. However, there are suggested templates through TXRAMP. Plenty of work has gone into developing those. And so we decided we can reuse those. We will accept other formats provided that they meet the criteria that are listed in the control requirements relating to these documents. However, if a standard approach such as our suggested templates are used by the vendors, that should expedite the processing as it's in a standard format. But again, that is not a requirement. We will accept additional formats and conduct the assessments based on those. So we are asking for the policies for the control families and then some system security documentation as well that we will review and incorporate into the methodology that we use to determine whether or not a certification can be granted. So it's really a controls assessment and the documentation that come together to make those decisions. High level here, this is probably more targeted for the vendor community, but from a general policy procedures requirements, the policies need to address the criteria that are specified within the -1 controls for all the families. That's those bullets there. And then the parameters associated with the policies are to review and update at least every 3 years. And then for procedures, it's review and update at least annually. And we are not requesting the procedures as part of our collection of artifacts, just the policies in this case, but we will be asking questions and looking into evidence surrounding the procedures through the controls assessment. And then identifying personnel roles to whom policies procedures are disseminated. If you look at any of the -1 controls, it's pretty explicit what the criteria is around policies and what criteria need to be included are. It wouldn't be a discussion on cloud security if there was not some form of this chart in here, talking about the shared responsibility matrix depending on where you are in the stack, there could be some gray areas or overlap depending on what level of the controls they are, and so on and so forth. So with that, I kind of just wanted to mention here that in the event that a vendor provides a capability, but it is ultimately a service configuration or a customer organization responsibility to ensure that this setting is appropriately implemented, those aren't going to immediately disbar an organization from obtaining a certification. However, we do want to be aware of that information so that we can communicate it and say to our organizations that are subject to this program, you need to make sure that XYZ is implemented on your side. And that should be captured within the system security documentation for the control implementation responsibilities. However, that's just a point I wanted to bring up. There is a lot of gray areas sometimes, so we do have to take into account inheritance and various responsibilities across the providers whenever we're going through and assessing this information. Okay, and then leveraging authorizations. Just going back to that same kind of example where there's different control responsibilities throughout the stack. It is quite often the circumstance where there is a SaaS provider that is leveraging another cloud that is lower on the stack, perhaps an infrastructure as a service to deliver their service as well. So they are dependent on another cloud for some of the security controls that we're requiring to obtain a certification through this program. So just because a SaaS provider resides in an authorized environment does not mean that that solution is secure whatsoever. It still needs to undergo an assessment. However, I do recognize that they are not fully responsible for all of the controls if they're leveraging a provider for their infrastructure. And based upon that, however they're leveraging it, if it is an authorized infrastructure provider, for instance, then we will permit inheritance of certain controls through that provider. And we've got a supplemental process here that essentially captures a memorandum that states that the SaaS solution will only leverage the certified or authorized IAS or PAS solution in a manner consistent and compliant with the requirements, so that then they may inherit those controls that are the responsibility of the infrastructure providers. Those are typically going to be your physical environmental controls, as well as some others that they aren't responsible for, but it provides us the evidence that they're operating in an infrastructure that has some sort of a certification or assessment related to it. Okay, continuous monitoring. So after the certification is complete, there are some ongoing activities that are required of the service provider to maintain compliance. And these are essentially vulnerability reporting and significant changes are probably the bigger ones here, but vulnerability reporting. So within FedRAMP and StateRAMP, there is a higher frequency required for the vulnerability reporting through our stakeholder discussions and our unique situation requiring all cloud service providers to be certified through this. We determined that for level 1 certifications, an annual report of vulnerability would be sufficient in this case. And then for the level 2 certified providers, a quarterly report of their vulnerability posture would be sufficient. And the vulnerability reporting requirements are based on the severity of the vulnerabilities identified. That includes what you see in this table to the right here, and that's the number of identified during the reporting period. And then side note here, to be sure, within the control requirements themselves, there are requirements that the vendor remediate vulnerabilities within a defined time frame. This is really more of a reporting standpoint for what was identified through that process, if there's anything outstanding, and then what the remediation activities or compensating controls are relating to those higher risk vulnerabilities. So it creates a touch point to where we still maintain contact with that vendor. It's not a one and done certification thing. They have ongoing responsibilities to maintain compliance. And at the same time, it gives enough space to ensure that organizations can manage this appropriately. And then critical security issues, if the vendor identifies a significant security flaw within their product that could impact the CIA, confidentiality, integrity, availability of a state of Texas system or data, they need to notify DIR within 48 hours of that discovery. And then again, aligned with the existing breach notification, of Texas requirements, the vendor needs to provide that notification to DIR within 48 hours of a breach of state of Texas confidential information or personally identifiable information. Obviously, there are caveats in there if law enforcement are involved, et cetera, but that's a standard that we have set forth for informing DIR of a timely fashion. And then significant changes. The program manual goes into more detail on what a significant change is, but a significant change largely is one that would likely affect the security posture of the cloud service. So moving to a completely new data center or something along those lines. Anything that would impact the implementation of the controls or the overall security posture as it was assessed at that point in time that we granted that certification could potentially fall under the significant change criteria. So the intent of this one is to make sure that we're staying up to date and we are updating our assessment information in a timely fashion, and so that organizations can act and make decisions on information that is most current, most accurate. So the significant changes are an important component of that in making sure that certain controls are updated as needed. How continuous monitoring actually works in this case, we will be utilizing the same mechanism that we are using to collect the assessment results initially. So that's through our vendor portal, and that information will be piped back into Spectrum. We will have automated reminders that get sent to the point of contacts relating to that cloud service for them to submit their ongoing monitoring requirements. That is, annually for level 1, quarterly for level 2. We'll send out those reminders with a link to the questionnaire for them to fill out. They complete it, note any additional relevant information for that given time period, and then we will also pipe that back in and provide that to the contracted agencies for review through Spectrum. Okay, additional information, starting to wrap up here so we can try to get some questions. Certification revocation. So I included this here as essentially be aware kind of thing. So vendors, this might pertain more to vendors as well, but failure to maintain compliance with the requirements, failure to inform parties, it's all the typical stuff you would think that could potentially result in a revocation. Failure to inform of a loss of other accepted RAMP certification. Obviously, if they lose their state RAMP certification, and that is what we had certified them under, we will inform all the parties involved in those cases. Failure to provide continuous monitoring information. Essentially, any violation could potentially result in a revocation of their certification. Obviously, this is not our first line of defense. We want to remediate these situations, maybe updating contact information. It may be providing more frequent monitoring. There are a variety of different corrective actions that can be deployed to ensure and make sure that vendors are staying accountable and staying in compliance with our requirements. So I just included this here based on the program manual. Grievances and appeals. So if an agency has observed a potential failure to maintain compliance with the given vendor, and the vendor is is reluctant to remediate whatever that may be, agencies may report those perceived failures to DIR, who then can step in and coordinate or work with the vendor to make sure that that is set up appropriately and they have the appropriate actions in place to remediate whatever the failure of compliance is. So that's what I get back to when it comes to ensuring that the vendors are being held accountable and that we are staying accurate. We need to know, since you're on the front lines handling with these vendors, we may or may not be contracted with them, if there are identified issues that need to be solved to help protect the state as a whole. Providers may appeal certification decisions to DIR as well. If they think that they should have been granted this certification and want to appeal it, then they can submit that information to us and we will review it and make a determination on if more information is required and so on and so forth, or work with that entity to make a final decision on that. Obviously, they can reapply for certification after they've been rejected, but our intention is not to just one and done either approve or reject. If there's more information that is needed from the vendor or clarification, we anticipate reaching out and communicating with them to either get that information so that we can make a more informed decision about certifying or not. And then DIR determines the corrective remediation revocation actions from a program's perspective, if they need to develop a POAM or if they need to increase frequency of monitoring, or so on and so forth, do a reassessment of certain controls if they move data centers. That's going to reside in DIR in making those determinations, but we are welcoming input whenever there are those situations where you see potential risk to the state in particular. Recertification. So level 1, level 2 certifications are valid for 3 years from the date of the last certification was conferred upon the cloud computing service. That is provided they've maintained compliance with the program requirements. The recertification process will be very similar to the certification process, wherein the vendor updates their controls, information, and documentation in line with the requirements of the program manual. So 3 years we determined was a valid amount, appropriate amount for revisiting and reassessing these services. Again, it requires the vendor to review and update implementation details as necessary. And we will launch reminders to the vendors beginning at 12 months and then again at 6 months prior to the certification end date to ensure that they have sufficient time to complete the recertification process and update and provide their updated documentation to DIR. Although if they are maintaining compliance, it should not be a heavy lift in the regard, as it should, or the vendor should continually update their program and make sure that the control implementations are relevant. Okay, so we have one other information session scheduled for this Friday from 9 to 10. We anticipated targeting that more for the vendor community, but there has been a large audience today. We are recording this session again, and we'll make it available, and we anticipate providing more information, documents, and FAQs. It looks like a ton of questions came in here, and I'll try to get to some of them after this. But we have that session on Friday. If anybody wants to register, we're limited to 500 again, but we will record that and post it as well. And then we will also be communicating a spectrum overview and training in the near future as we deploy the tool into production and begin launching assessments and conducting the review of assessment responses. So we have an email set up. It's tx-ramp@dir.texas.gov that you can reach out to with any questions in the meantime. Again, this is really meant to be kind of a high-level overview. We will take these questions and we will digest them, incorporate them into our into our FAQs and information that we publish going forward. So with that, we have quite a list of questions here. I'm going to pick some.